Welcome to the debate. When you study property law, the concept of a boundary is usually absolute. You look at a surveyor's map, there's a bold red line, and it's definitive. Yours, mine. You don't need a judge to tell you where the physical fence post is actually buried.
Right. Yeah, it's an objective reality. I mean, the land registry does the heavy lifting long before anyone ever argues over a trespassing claim.
Exactly. But in employment law, specifically the enforcement of statutory workplace rights, that boundary line was practically invisible for decades. It really only materialized if an individual had the courage, the financial resources, or, perhaps the sheer desperation to build a lawsuit just to find it.
Yeah. The map was only truly drawn after the dispute just completely exploded in an employment tribunal.
Precisely. But as of April 2026, with the formal launch of the Fair Work Agency, the FWA, the state has stepped into the labor market with a very heavy surveyor's transit. We are examining a monumental paradigm shift in the UK today.
A massive shift.
Truly, we are looking at the complete departure from a reactive tribunal system to a landscape of proactive state inspections. And this is all driven by the May 2026 policy paper concerning the FWA and the National Workplace Adjustments Framework. Now, as a solicitor aligned with regulatory enforcement, I look at this shift and I see the necessary systematic accountability that our labor market desperately lacked.
Right. And as a business defense lawyer, I look at that exact same surveyor's transit and I see an instrument of blunt force. I mean, the traditional tribunal model, for all its flaws, actually handled the granular complexities of human employment relations. This new regime of blanket state auditing, it risks punishing good faith businesses through vast automated regulatory overreach.
Well, let's test that defense immediately, because we really need to look at what the Employment Rights Act 2025 actually dismantled. You defend the traditional tribunal model, but let me put this to you. How can you argue a legal system offers genuine justice when its primary mechanism relied on vulnerable individuals risking their jobs to expose systemic wage theft?
I wouldn't say it relied on that.
But it did. Under the old regime, if a worker was denied basic holiday pay, they had an incredibly narrow, unforgiving 3-month window to file a claim. That limitation period was effectively a shield for corporate noncompliance.
Okay, but you're framing the 3-month limit as some kind of trap. Mechanically, it was a necessity for due process. It ensured claims were brought while the evidence was actually fresh.
Fresh evidence, right?
Yes. While managers still remembered the specific conversations, and while records were readily available, it was about adversarial testing of actual specific harms. Now look, I will concede that the barrier to entry for a claimant was high. But look at the pendulum swing with the FWA's new powers.
I think the swing is exactly what we needed.
But is it? You now have an agency that can just drop notices of underpayment on a business within 28 days, and it wields a staggering 6-year look-back period.
Which fundamentally shifts the burden of proof to where it belongs, onto the employer.
It shifts the burden, yes, but it obliterates proportionality in the process. Let's actually look under the hood of these FWA enforcement mechanisms. The FWA can impose automatic financial penalties of up to 200% of the unpaid amount.
A strong deterrent.
But crucially, that 200% doesn't go to the worker to make them whole. It's payable straight to the government. And on top of that, you are holding the threat of criminal liability over the heads of company directors for inadequate records. Let me ask you, does a 200% punitive fine for a good faith calculation error genuinely improve workplace equity? Or does it just generate a culture of regulatory terror?
Well, that argument assumes that good faith calculation errors should be subsidized by the worker, and they shouldn't. Plus, we need to be precise about what these so-called errors really are. Let's look at holiday pay for gig workers, or those on irregular hours.
Right, the 52-week reference period.
Exactly. Under the law, you have to use a 52-week reference period. You look back at the last 52 weeks the employee actually earned pay, skipping the weeks they didn't, to find their average weekly pay.
Which is an absolute mathematical nightmare for legacy payroll software to track. You know this.
But complexity is not an excuse for wage theft. Take a massive logistics corporation. They utilize incredibly sophisticated routing algorithms, right? They can track a delivery van's fuel efficiency down to the drop. They adjust dynamic pricing to the cent in real time based on weather patterns.
Sure, the tech giants can.
Yet, when it comes to running a 52-week reference period to calculate holiday pay for a flexible driver, they suddenly throw their hands up and claim the math is just too hard for their payroll software? Come on, I don't buy it. The 200% fine shifts the corporate risk calculus. Under the old tribunal model, the rational economic choice for a bad actor was to systematically underpay everyone, knowing only a tiny fraction of workers would ever sue. The FWA's data-driven audits destroy that calculus.
Okay. But you are conflating intentional exploitation by massive tech giants with the reality of overwhelmed administrators at mid-sized businesses. Let's look at a regional haulier with, say, 300 drivers on varying shift patterns.
Okay.
Their payroll software isn't some bespoke AI. It's an off-the-shelf program from 5 years ago. Let's say a driver takes intermittent unpaid sick leave. The software attempts the 52-week reference calculation, but due to a missed API handshake, it pulls a 48-week average instead.
That's a specific example, but go on.
It results in a £3 underpayment per week.
Which is a statutory violation.
It's a microscopic software glitch, but because the FWA automated system hooks directly into payroll data now, it catches that discrepancy across 300 employees over 6 years. Suddenly, an administrative rounding error results in a catastrophic punitive fine payable to the state. The FWA applies a strict liability financial sledgehammer.
Because the workers were shortchanged.
But in a tribunal, a human judge could look at the context. They'd see the business attempted the calculation but failed due to an IT error and just order them to pay the arrears. The FWA algorithm removes the human element of justice entirely.
The human element of justice was historically denied to the worker who couldn't afford the barrister to argue in front of that judge in the first place. The FWA's algorithm isn't malicious, it is impartial. If the math is wrong, the worker is being deprived of earned wages.
But it fundamentally treats administrative friction as moral failure. It operates like a check engine light in your car that doesn't just warn you about an emissions issue. It automatically deducts a £5,000 speeding ticket from your bank account without even knowing if the car was actually moving.
Look, I think that analogy completely misrepresents the compliance tools the state has actually provided. The FWA isn't just acting blindly to catch errors. And this brings us directly to the National Workplace Adjustments Framework, the NWAF, and the introduction of digital adjustment passports.
Ah, the safe harbor provision.
Exactly. The state has literally given businesses the blueprint to avoid these penalties. The May 2026 policy paper explicitly details that if an employer integrates their systems with the NWAF technical standards by adopting digital adjustment passports, they are shielded. Let me defend this architecture because it's revolutionary.
I'm listening.
Previously, what did a reasonable adjustment look like? A neurodivergent employee asks their line manager if they can wear noise-canceling headphones and start at 10 a.m. to avoid rush hour. The manager says sure. It's an ad hoc, undocumented agreement.
Which works perfectly fine for them.
Until 6 months later, when a new manager comes in, demands everyone at their desk by 9 a.m., and suddenly we have a constructive dismissal claim. And then we have a tribunal fight over whether the adjustment was reasonable.
And the tribunal decides based on the specific operational needs of that business.
Yes, but years later, after the damage is already done. The digital adjustment passport codifies it immediately. It integrates the adjustment directly into the HR and payroll infrastructure using NWAF technical benchmarks. It clearly defines what good looks like.
In theory.
In practice, if you adopt this passport, you have undeniable empirical evidence of your compliance. You've mapped your practices to the state standards, definitively reducing the need for arbitrary agency intervention because systemic accountability is literally built into the business's DNA.
Well, that sounds beautifully pristine in a policy paper. Now let's look at it from the perspective of the lawyer defending the business when that pristine system hits reality. You call the digital passport a shield, but the data architecture suggests it is actually a centralized target for the FFWA.
Wait, how so? How is a compliance tool a target?
Because human beings, particularly when we discuss neurodiversity or physical disability, do not neatly map onto predefined technical parameters. Let's take your exact example. The neurodivergent employee who needs a fluctuating start time.
Right.
The human manager and the employee agree on a bespoke, highly nuanced working arrangement that changes week by week based on the employee's sensory overload.
It is a fantastic, deeply compassionate accommodation.
Which the passport protects.
No, which the passport rigidly categorizes. If the employer's bespoke adjustment doesn't perfectly align with the rigid digital reporting benchmarks required by the NWAF for that specific month, what happens?
The system handles variations.
The payroll system fails to perfectly synchronize the fluctuating hours with the state's rigid API. And the FAO's automated systems, which have proactive access to audit these passports, flag a discrepancy between hours worked and standard hours expected. The employer is now facing a massive audit, not because they failed the employee, they actually accommodated them perfectly, but because they failed the database.
You're assuming the NWF benchmarks are a ceiling that restricts accommodation. They aren't. They establish the minimum acceptable technical standard for the administration of the adjustment.
But administration dictates the reality on the ground.
Not medically. The FWA is not policing the medical efficacy of the bespoke schedule. They are policing the administrative reality to ensure that a fluctuating schedule doesn't result in systemic wage theft. If the employee works fewer hours one week because of the adjustment, the passport ensures their holiday pay accrual is correctly prorated according to the law, not just eyeballed by a manager.
Okay, but the moment you centralize this into a digital passport graded by an agency inspector, you strip away the nuance of the specific employer-employee dialogue. An inspector sitting in an FWA office looking at an automated flag doesn't see the compassionate manager. They see a data breach.
It's an administrative check.
The defense lawyer's nightmare is that the FWA inspector uses the NWAF benchmark as a rigid compliance checklist. They end up penalizing employers who tailor bespoke solutions simply because the state's algorithm doesn't recognize them.
If the solution results in the worker being paid less than statutory minimums for the hours they did work, or if it inadvertently strips them of accrued benefits, then it's not a legal accommodation. It's a liability. Look, the framework forces businesses to realize that human resources and payroll can no longer exist in separate silos. The reasonable adjustment must mathematically flow through to the payslip flawlessly.
Which brings us to a profound reality for the next generation of legal practitioners. If you look at the curriculum for undergraduate law students today, the landscape they are stepping into is virtually unrecognizable from the textbooks published just 5 years ago.
Oh, it is a complete paradigm shift. And frankly, the advice to any undergraduate law student studying this framework right now is that you must recognize we are officially at the end of the voluntary compliance era.
Yeah, the days of waiting for a claim to arrive in the mail are dead.
Absolutely dead. If you are training to be an employment solicitor today, the drama of the courtroom cross-examination is largely being replaced by the rigor of the compliance audit. Your focus has to pivot. You must become part lawyer, part systems architect. You need to understand how payroll algorithms function. You need to know how the FWA API interacts with legacy HR software.
Right. You essentially have to speak the language of data fidelity.
Precisely. Because the FWA's ability to demand records stretching back 6 years means your primary role is no longer just defending a client after a tribunal claim is filed. Your role is auditing their entire digital infrastructure before the FWA inspector's algorithm ever flags them.
A preventative approach.
Exactly. If you understand the NWAF technical standards deeply enough, you build a fortress of compliance around your client. You don't need to fight the FWA if your client's digital adjustment passports inherently, mathematically prove that statutory rights are flawless realities.
Well, I would issue a stark warning to those same law students against adopting that mindset too completely. Do not throw away your litigation textbooks just yet.
Really? You think adversarial skills still take precedence over compliance architecture?
I think they have simply shifted venues, and honestly, they are more critical than ever. You must not allow yourselves to become mere compliance officers who surrendered to the algorithm.
But the mechanism of scrutiny is administrative now. You are arguing with an inspector's notice of underpayment based on a data flag, not a claimant's barrister in front of a judge.
Exactly, which makes the adversarial skill vital to protect businesses from crippling state penalties. When an FFUA inspector uses NWAF benchmarks to determine if a policy is discriminatory,
They are not just checking math, they are making a legal judgment embedded within a technical standard.
Right, but
The definitions of what constitutes a reasonable adjustment under statutory law still require intense legal scrutiny and definitional precision.
even when codified in a digital passport?
Especially then, because the friction of real-world commerce guarantees anomalies. A flawless execution exists only in theory. When the FFUA drops a 200% fine on a business based on an automated flag, treating an administrative anomaly as a moral failure, you must be able to aggressively challenge the agency's interpretation of that data.
Challenge the data, sure, but the underlying facts are the facts.
You have to be able to argue that the employer's bespoke adjustment met the statutory spirit of the law, even if it triggered a rigid NWFA technical benchmark. The state has immense power in this new paradigm. Defending a business against the crushing weight of the FWA requires a fierce adversarial mindset to challenge regulatory overreach.
But surely it is better to prevent the 200% fine by mastering the compliance framework than to rely on arguing about the spirit of the law after the state has already frozen your client's assets or issued a 28-day notice. The proactive model protects the most vulnerable workers who could never access the tribunal system by forcing the employer to prove they are obeying the law every single pay period.
At the dangerous cost of proportionality. Yes, deterrence is achieved, but by replacing targeted, evidence-based justice with blanket audits and strict liability fines, we risk punishing good faith businesses for the sheer, genuine complexity of the modern labor market.
Well, we can debate the proportionality of the fines, but looking at the April 2026 implementation, we have to converge on one undeniable reality here. This permanently alters employer liability. It fundamentally changes the mechanics of how employment law is practiced in the United Kingdom.
Oh, without question. The underlying legal theory remains, but the operational reality of advising a business has completely transformed. Understanding both the regulator's systemic auditing mindset and the business lawyer's necessary defensive strategy against data-driven enforcement, it's the only way to master this new ecosystem.
The highly technical integration of NWAF standards into existing payroll software is going to produce friction we haven't even anticipated yet. How these digital adjustment passports will actually hold up under real-world regulatory stress testing is the great unknown.
It will certainly be the defining legal challenge of the next decade. The mechanisms of enforcement have shifted from the courtroom to the server room, but the fundamental tension between the power of the state and the operational realities of enterprise remains as complex as ever.
Indeed. We began today by talking about boundary lines, how the property surveyor's bold red line contrasted with the historically invisible, highly precarious boundaries of workplace rights. Today, with proactive algorithms and mandatory digital passports, the state has drawn that boundary line in thick, indelible ink across every payroll system in the country. The question that remains for the practitioner stepping into this new reality is no longer where the boundary is, but whether the digital fence they've built is keeping exploitation out or merely trapping everyone in an unforgiving cage of compliance.